Section 21 will be gone, and that applies to both new and existing tenancies. But that doesn't mean landlords can't ask tenants to leave. An updated version of Section 8 will take its place. The key difference is that Section 8 will require landlords to provide a valid reason for ending the tenancy and will involve a more structured administration process to bring a let to an end. Moving forwards, landlords will be able to regain possession using Section 8 when selling, moving in themselves, or letting to family instead. Fixed-term tenancies are being scrapped for both new and existing lets. That means tenancies will no longer have a minimum term, and they will no longer have an end date either. This gives tenants more flexibility and control over how long they stay, but they will still need to provide 2 months' notice whenever they wish to leave. This notice will have to expire in line with rent due dates in future, which makes some elements of tenancy administration easier for landlords to manage. Tenants will also benefit from a 12-month protected period at the start of each let, meaning a landlord cannot serve notice within this timeframe unless there is a breach of contract. When it comes to negotiating tenancy terms, there will be fewer variable elements for landlords and tenants to consider. Landlords won't be able to accept more than 1 month's rent up front, and overbidding will be prohibited in the bill. That means landlords will not be able to accept any offer above the guide price in future. Landlords will also be prevented from discriminating against tenants who receive benefits or who have children or pets. But landlords will be able to ask for pet damage insurance. There will be a new ombudsman scheme, which all landlords and agents will have to join, delivering a dispute resolution option for landlords and tenants. There will also be a new property portal, where all rented homes across the country will be listed, plus a revised Decent Homes Standard, which will apply to the private rented sector as well as to social housing. This will include AWAB's law to protect tenants against the dangers of damp and mould. But until it is applied, the current housing health and safety rating system will continue to dictate the standards that privately rented homes must meet. Lastly, there will also be a register for short lets to keep track of licensed short stay properties. Some things remain the same, including HMOs and selective licensing schemes, which are run by local authorities and won't change. Also, contractual or non-Housing Act tenancies will remain unaffected by the bill, meaning landlords may still be able to let properties for fixed terms and accept rent up front as long as some specific conditions are met. For advice and further detail on these points, your Hamptons lettings experts are here to help guide you through these changes and ensure that you remain compliant and confident as we navigate the future together. Find out more on our website at hamptons.co.uk.